Power of attorney, or POA, is a legal document that authorizes one person to act on behalf of another in legal or financial matters. In the Netherlands, having a POA is crucial for efficiently managing affairs, especially in situations where individuals are unable to communicate or make decisions themselves. In the Netherlands, there are two main types of power of attorney, general and specific. A general POA grants broad authority for various matters, while a specific POA limits powers to particular tasks or timeframes. Understanding these distinctions helps individuals choose the right type for their specific needs. To create a valid power of attorney in the Netherlands, individuals must be at least 18 years old and possess the mental capacity to understand the implications of granting authority. Necessary documentation typically includes identification and a specific POA draft, often requiring notarization for legal recognition. To obtain a power of attorney in the Netherlands, first draft the document outlining the powers granted. Then, visit a notary to have the document officially executed and notarized. Finally, register the POA with the appropriate authorities to ensure it is legally recognized and enforceable. Common mistakes when creating a power of attorney include unclear language, not specifying authority limits, and neglecting proper notarization. To avoid these pitfalls, ensure clear and precise wording, define the scope of powers appropriately, and always involve a notary for legal validation. These steps help ensure the POA's effectiveness. In conclusion, creating a power of attorney involves understanding its types, meeting legal requirements, and following proper procedures. Ensure clarity in the document, involve a notary, and double-check all details. These final tips will help you navigate the process smoothly and ensure your POA is effective and reliable.